morning. Please be seated. We are here for oral argument on Gelvin versus the Honorable Parker / Gelvin. It's our number CV-25-0116. A couple things before we get started. First off, Justice Mary Elena Cruz has recused herself in this matter, so joining us today is former Justice John Palander. Thank you, Justice Palander, as always, for coming up and filling in. It's a delight having you here. You all know you have 20 minutes each. You keep your time, whatever time you'd like for rebuttal, but you have to keep your time yourself. There's a clock at the podium for that purpose. Please begin.
Good morning, Justices. May it please the Court. My name is Marcus Reisinger. I'm joined at counsel table by Melinda Sloma, the trial counsel for Care Gelvin. He's the real party in interest in this case. This case concerns the extent to which a third-party witness may involve themselves in a litigant's relationship with their attorney before the attorney-client privilege stretches past its logical breaking point. According to the memorandum decision below, relying on Accomazzo versus Kemp, there is practically no limit to the scope of the privilege as long as the third party agrees to keep their communications with the litigant and the litigant's attorney confidential, and the client herself subjectively believes that privilege applies. However, the Court of Appeals and the trial court both expressed grave concerns about whether Accomazzo can be squared with well-established principles governing the attorney-client privilege. The Court of Appeals wrote that Accomazzo warrants a second look in the appropriate case, and we urge the Court to take that second look today. I'll begin by going over the issues raised in the petition for review, the issue the Court added for today's argument, and distinctive features of the Accomazzo case itself that materially differ from the instant case.
What are we to make of the fact that, as far as I can tell, it was not until you reached this court, the Supreme Court, that you asked for this case to be, you asked for Accomazzo to be overruled?
Well, two things, Your Honor. First, my client's position is that the materials are discoverable, and he believed up until reaching this court that Accomazzo simply didn't apply to them, that these communications that took place outside of the client's presence, without the client's participation, and were not intended or meant to deliver legal services to the client or convey information from the client to the attorney, they simply weren't privileged even under a reading of Accomazzo. Second, there was never really an opportunity to ask to overturn Accomazzo because the trial court found that it didn't apply. And then the Court of Appeals for the first time said that yes, Accomazzo does apply to those independent communications between the litigant's attorney and the third-party witness. So although he is asking for Accomazzo to be overturned, or at least limited today, his position has always been that the materials were discoverable, whether Accomazzo is good law or not. And we believe that's true, especially in response to the court's added issue about retroactivity, because from our position, it's not a reasonable belief that these materials or these communications were privileged under a reading of Accomazzo without having to reach whether it's correct or not.
Well, to that point, the Court of Appeals said that Accomazzo expressly extended to direct communications between the mother and or the parent and the lawyers, but I couldn't find anything to that effect in Accomazzo. Do you read it otherwise?
I don't believe that Accomazzo was written to cover those direct independent communications. Having looked through the opinion numerous times, I found only a couple of very vague references to that concept. One is in paragraph 13 of Accomazzo, which lists out elements of the affidavit that the client wrote in that case. Number 7 says, I believed my communications with Mr. Cohen, her attorney, including those where my parents were present, were confidential. I also believe the communications of my parents with Mr. Cohen as my representatives were confidential. Now, that alludes at least to the fact that the client believed the communications independent of her participation or presence were privileged. But I don't find that to be a reasonable belief given the broader body of law. And nothing in Accomazzo expressly says that those communications are included. And that's what the trial court struggled with and contoured this order very carefully to try to get around. Akamazo is binding on the trial court, so we will treat communications between client, attorney, and parent as privileged, but not the communications that were independent of that and weren't for that same purpose. So this is really the first point that I wanted to raise today, and the first point that was raised in the petition for review is that the privilege is not intended, nor has it historically been used, to make confidential between the communications between a lawyer and a witness who's not the client.
Do you agree, though, that, I mean, there are times in which, in order to have that confidential communication and advice free exchange between the client and the attorney, that sometimes you need a third party present there? Maybe it could be a parent if it's a minor. Maybe it could be a guardian, an interpreter, or somebody, as at least a federal court has held, with a particular expertise in a complicated matter, like a tax expert or accountant. Do you disagree with that?
I don't, and I think these are the points that were mostly raised in the amicus brief. And I think all the parties agree with the concerns expressed in the amicus brief. We just disagree on whether Akamazo is necessary
Right.
to protect those
Well,
interests.
and of course, we're not bound by Akamazo. So what do you propose the limitation we should put, since you acknowledge that, yes, sometimes you need somebody else there? What's the test that you would propose that we impose?
So Arizona law has generally followed the restatement on this point. And generally speaking, a third party's participation in the communications presumes a waiver. Akamazo doesn't do that. Akamazo presumes non-waiver in the opposite direction. The exceptions to that presumption of waiver are based on agency and essentiality of that third party's participation. And I believe that all the concerns expressed in the amicus brief and that you've expressed today are resolved by just applying those two factors, as all the case law did prior to Akamazo being decided. And in fact, when Akamazo is cited today, in the vast majority of cases, it's not cited for its own holding, it's just cited for its favorable treatment of those standards. The Suchru case is one of them, which speaks to the necessity element. This is a minor child client whose parents take an interest in his legal affairs. That's different than a capable adult who has a confidant who wants to participate.
I agree with regard to the facts of, I don't know how to pronounce it, but I was calling it Sukro, but there's language in there that is very similar to the language in Akamazo with regard to intent being determinative and subject, and it is a subjective rather than objective analysis. Would we, assuming that that we agree with you that certain parts of Akamazo are inconsistent with case law, wouldn't we have to address that paragraph also in Sukro?
I believe you would. And I think that subjective element, that the controlling standard is the client's reasonable belief rather than the necessity or the essentiality or the agency relationship, is where Akamazo goes wrong. So certainly the client's belief is relevant to the conversation, but it can't be the controlling standard, because what that does is shifts the burden to the opposing party to try to allege facts that the client didn't believe that the communications were privileged. And I don't think that's possible to do. I believe that if we stick to the agency exception and the essentiality exception, that resolves the majority of the problems. It allows an attorney in this modern era to deliver legal services to the client in a way that's effective, and for the client to convey information to their attorney without vitiating the privilege. And it doesn't create a scenario like in this case where this client's subjective belief can be used offensively as a sword rather than a shield to bar the opposing party's access to a critical witness simply because they've signed an agreement that says they won't discuss or disclose any of the information that they've received about the case with any third parties.
I agree with you that the concept of agency and essentiality provide a framework, but the devil is in the details, of course. Would you extend this concept of agency and essentiality to individuals that the client has identified or asserts is an agent or an essential witness?
The devil is certainly in the details, Your Honor, and it's a difficult line to draw. What is it that makes someone an agent of the client or makes their participation essential in that context. And I think that has to be somewhat of a case-by-case analysis. In a case like this one, where the client is capable and the attorney is capable of communicating with one another and delivering legal services and advice without the need for that third party, then I believe it shouldn't be treated as privileged, because that third party's participation may be convenient or comforting to the client, but it isn't necessary, and it doesn't enable the attorney to deliver legal services that they otherwise wouldn't have been able to do. In
So
fact,
suppose in this case, the wife was not, the only relationship she had with the trust was getting checks and really didn't know anything about the mechanics. And they brought the mother in to find out, the technicalities of the trust and how it worked. Would that potentially bring that third party into the confidentiality?
I think it's only if they are strictly necessary in order to determine how the trust ought to be treated. And there are two cases cited in the concurring opinion below that speak to this. One is United States versus Covell. In that case, the attorney hired a tax expert as a consultant to assist himself in gathering information from the client, because the client wasn't a tax expert. He couldn't deliver that information to the attorney in a usable form, nor could the attorney convey legal standards and advice about those tax issues to the client without the help of that third party. And that's totally consistent with how we use experts, consulting experts in Arizona. The second case was National Steel Producers versus Superior Court in California, a similar scenario. There, the attorney hired an engineering expert in order to convey information from the client to himself and vice versa, because it was necessary to do that in order for the attorney-client relationship to work. There are certainly other scenarios where I think it's fairly obvious that a third party's participation is necessary. If there's a language barrier between the attorney and client, certainly a third party needs to be involved. But if that person is not an expert, they're not a true third party, and they're not a true agent, the court should be cautious about allowing the client's subjective intentions to be the controlling standard because of a situation like the instant case. If the client can designate a person they trust, whoever that person is, and essentially insulate them from discovery, then the attorney-client privilege is now too much of a barrier to the court's fact-finding functions.
Didn't the trial court here, I was looking for it, but I couldn't find the language just off memory, though. Didn't the trial court make some type of finding that the mother was necessary to be in those conversations, at least with the ones where the wife was present?
Not to my knowledge, no. The trial court expressly found that the participation of the third party for a fit adult client isn't necessary and wasn't necessary specifically in this case. And that's why the court, even though it felt that it wasn't necessary, Accomazzo was its controlling standard, which doesn't have a necessity element. There's no essentiality requirement in that case. So I think the court clearly wanted to say, if the person's not necessary, then the communications aren't privileged, but couldn't do that because Accomazzo controlled it.
But one of the limiting principles that you propose is agency, and I'm wondering what then prevents, like in this scenario, the wife could simply designate her mother as her agent for purposes of discussing and making even decisions to instruct the lawyer. Would that suffice then?
Well, I can imagine a worse scenario or a more challenging scenario, which I think the amicus brief touches on, which is a client who's incarcerated and their attorney needs someone who's not incarcerated, who the client trusts to go and take acts that the client would otherwise take. But there, the client lacks capacity for some reason, whether that's age, infirmity, legal capacity, or just physical restraint. They can't go and do those things for themselves. So they may designate a family member or a friend as an agent for the limited purpose of gathering certain information or taking certain steps on their behalf, just as they would with a legal guardian or a power of attorney or something of that nature.
Counsel, let me ask you a question about that, because it seems in that instance, talking about someone who's incarcerated, that kind of conflates agency and essentiality. If the client's incarcerated, obviously they can't meet with the attorney. They can have a legal call, but maybe there's something else that has to occur. Maybe papers have to be transferred or what have you. So I guess my question is that should we look at agency as just being one way of identifying who someone is in the relationship to the client, but really place emphasis on whether or not their involvement is essential or necessary to the delivery of legal services, or for the client to understand the advice that they're receiving.
It seems to me that the essentiality and the agency elements are very close and do overlap quite a lot. So,
And aside from instance in which someone's incarcerated, in which, you know, we might consider the capacity or vulnerability of the client in question, should we require the client to be present for communications?
well, I think what the trial court did, and I think it was a wise approach, is to look to the purpose of those communications. Because we can imagine a scenario where the client isn't physically present or isn't on the phone call, and the attorney is just conveying sort of general information about the status of a case, or asking the agent to do something, and those communications probably need to be privileged. But independent communications for a completely different purpose. These are sort of strategy conversations in which the third party is now injecting themselves into the litigation and simultaneously using the privilege as a screen so that they can't be deposed or brought in to speak about those things.
And to that point, I guess that's where trying to draw a bright line gets kind of fuzzy, because we say independent communications, but if we focus on whether or not the involvement of this third party was essential, does the fact that they were independent really matter?
I still think it does, and there are some cases that are cited in the briefs below and in the memorandum decision that talk about the purpose of the communications, and one of them is Arizona Independent Redistricting Commission versus Fields, where legislative communications and non-legislative communications are treated differently. And it's the same people in the same sort of context making those communications, but the purpose is not the same. And in other scenarios where the purpose of the communication is the telltale sign or the controlling element of whether it's privileged, courts have used in-camera review to make that determination. And that certainly could have been done here, but I think the trial court didn't think that was necessary, or at least not necessary at that point in time, because the special action hadn't been filed yet, right? So we're now in that scenario where on remand, perhaps, or not remand, but on returning the special action to the trial court, the trial court may need to look at communications in camera to determine, was this for the purpose of enabling the attorney-client relationship, or was it not? My preference would simply be, if it's not necessary and the third party is not an agent, then it's not privileged at all. But then we reach that retroactivity concern that the court expressed in the issue that was added for today.
One of the
And I
things you
was
just,
and I was hoping you could address that as well, the prospective applications. If we decide that Akamazo was wrongly decided, what's your best argument for why we shouldn't apply that decision prospectively only?
I think all parties agree it would be wisest to apply that decision prospectively only. But my position with respect to the communications in this case is that the communications the trial court ordered to be disclosed were not privileged under Akamazo in the first place. So it wasn't a reasonable belief of the client in this case that these were privileged communications, because Akamazo simply didn't cover them.
Yeah.
So the trial court got that right.
I believe it did. And the Court of Appeals strongly suggested in its special concurrence that the trial court was on the right track, but felt that in this case, Akamazo was controlling and they weren't willing to overturn it. But we believe that the trial court's decision was very carefully drawn out, not to get into the attorney-client relationship, but only to get into the communications independent of that between the attorney and the witness. And before I break to save some time for rebuttal, I would ask the court to consider the scenario if the third party who's designated in the Akamazo agreement is not the parent of the client, but is an employer. Because that's functionally what we have here. It's the source of the client's income. I don't think the court could ever imagine a scenario in which barring the opposing party from seeking discovery from the employer could be defeated simply by the client and the employer agreeing that their communications would be confidential.
but to be clear, it doesn't shield information about the trust. The mother can still be deposed and questioned on facts about the trust. You can't hide facts simply by communicating them to a lawyer, and you don't argue otherwise, correct?
I would like to think so, and I think that's the trial court's determination, that there was subsequent litigation about subpoenas and discovery and the trust not being produced. And there, before the case was stayed at the trial court level just a few weeks ago, pending was an objection, a motion to quash a deposition of Mrs. Giebert, the third party. So the position in the trial court seems to be that all of her communications are privileged. And at least on its face, the agreement she signs suggests the same, because it says all information that she obtains about the divorce is privileged. That theoretically includes anything that she would have to say about the trust. And that is part and parcel to the problem here. That's what creates the unfairness and the barrier to truth finding that I think the court is struggling with below. With that, I'd like to reserve the rest of my time for rebuttal.
Sure. Okay, Mr. Swan. And by the way, before you announce yourself, you don't, my understanding is that your argument is not as wide encompassing that the privilege shields anything other than communications. It doesn't shield facts independently known by the mother. Is that correct?
That's absolutely correct, Your Honor.
Yeah.
Absolutely correct. So may it please the court, Peter Swan and with Vale Clore on behalf of respondent Tina Gelvin. Your Honors, before I begin the formal argument, I just want to dispel any notion that I might be here because of any special relationship to the Accamazo case. I was hired before this issue came up. This is a coincidence I've faced before, and I don't claim any special subject matter expertise or insider knowledge. I'm just here to protect the interests of a single client, Tina Gelvin.
So does that mean you have no pride of authorship?
Very little, Your Honor. Very little. As a matter of fact, I'm prepared to take some hits here, and I'll point some out to you in terms of where I think the language of Accamazo could probably be tightened up to the public benefit.
Just on that point, Accamazo seemed to jump straight to the waiver issue,
Yes.
As opposed to going through the what I call the four factors of a prima facie showing that an attorney-client privilege even exists. Was that just because they were so obvious in that case, or was that a misstep in the analysis in that opinion?
Well, I think in that case, I suppose obvious would be one word, not contested would be another word. In this case, and in Accamazo, the basic elements of establishing the privilege are pretty clearly met. The burden remains on the person asserting the privilege. That burden was not overturned in Accamazo. This is a case about waiver, not about the existence of the privilege. There's no question that Mr. Pollitt was advising his client, Tina Gelvin, often in connection with communications with her mother, Ursula, and that those communications were standard, appropriate attorney-client communications. There's been no argument to the contrary. What is the argument is that there was a waiver by virtue of the inclusion of Ursula in those communications. And to your question, Justice Timmer, they've never deposed Ursula. All of this talk about independent communications with Ursula being strategy, and that's mere speculation. There is absolutely nothing about the facts Ursula knows that are relevant to these trusts, that are relevant to this case, that isn't fair game for discovery. It's just that hasn't happened yet.
To the extent that is relevant to any of our analysis, though, counsel, at least as I read the record, that there were documents about the trust that had yet to be disclosed that I think at least presumably for preparing for a depo, the other side would want to have first?
That may well be, but I think that's a separate issue about trust law that falls outside the scope of the privilege inquiry. If there's going to be a fight about whether Kerr is ready to take Ursula's deposition because of issues pertaining to trusts, so be it. But that doesn't mean that you go first for the attorney-client communications. If I could identify one of those areas where I lack pride of authorship, one of those areas where I think Accamazo gets us into trouble, it is the word presence. Because it doesn't take into account, while it took into account the facts of that case, it doesn't take into account the realities of modern lawyering. Modern lawyering, advice comes by phone, it comes by email, it comes by text sometimes, and it is not always clear who reads those communications first. It is not always clear that the client was available for consultation. In this case, though it hasn't come up in the Court of Appeals decision, it was raised below that Tina was undergoing treatment, that she had diagnosed PTSD, ER 1.14 was invoked below, and so when we just say a fit adult must be present, that doesn't really fit the facts of this case.
Well, one of the things that, and what you're touching on with the PTSD and all that, strikes me as more of that essentiality component that we were talking. It seems like both of you agree that somebody can be present on occasion, and we're in search of the limiting principles there. In Accomazzo, it seemed to go on, well, you say, the critical question whether the client reasonably understood the conference to be confidential, notwithstanding the presence of third parties. That, to me, is concerning if you look at that alone, because you simply need the attorney not to tell the client to expect that these will be confidential, or the confidentiality be waived if somebody else is present. You can simply say, well, and of course any client thinks, well, I reasonably thought that it was confidential because nobody told me otherwise. So can you alleviate my concern of why that would be the critical question rather than it's essential in some form, that the person be there, maybe for the reasons that you express, along with the person reasonably expected it to be confidential?
Well, Your Honor, I'm not sure I do agree either with the agency concept or the necessity concept. Agency appears in ARS 1222-34 as it relates to entities. And formal agency is often not an appropriate model for a family relationship. Whether a communication or involvement of a third person in the communications is essential, I think is factually almost impossible to determine in a lot of cases. A client may well feel that she needs the involvement of a third party to process the advice she's receiving, that she needs to bounce the implications of that advice off the third party, and certainly when we're talking about the closest relationship, the family relationship, it seems to me anomalous to say that in the midst of a case that threatens the stability of a family, which almost every divorce case does inherently, that the remaining family relationships should somehow be suspect.
Okay, but you're not really zeroing in on my question on that, because you're kind of veering off really more into that, whatever we're calling it, that essentiality element with, well, she needs her mother there or a family member there. It's a stressful time. That has nothing to do with expectation of confidentiality, or very little to do. My concern is more if we go with simply the critical question, as Accomazzo says, about reasonably understood. In any scenario outside the family context, you could simply answer a call from your lawyer, put it on speakerphone. There happens to be 10 people in the room, and, well, nobody told me. I thought I'm talking to my lawyer. It's confidential. So all those people, it's okay. So there has to be something in my mind beyond just, well, I thought it was confidential, and then that's the determinative factor. That's what I'm trying to get you to zero in on beyond the family context.
Okay, I think I understand the question better now. I appreciate that. I would agree with you that if a client simply turns on the speakerphone and has a group of people informally there to bounce stuff off of, that's probably too informal to preserve the privilege. I don't think that evinces a reasonable expectation of confidentiality. And while Accomazzo doesn't require an Accomazzo letter, which we had in this case, I would point out that Accomazzo is related to the common interest doctrine, which similarly does not require a written instrument. However, both, I think, raise the practical concern of what is just too much dissemination. And I think the question is well warranted, and there does need to be a line there. Can that line be written brightly? I'm not sure.
So what would you propose the line to be?
Okay. I would suggest that returning to first principles, and I come back to two first principles. Number one, when does the attorney-client relationship exist? It is not with the presence of a written retainer agreement. It is based on the subjective but reasonable belief of the client. When does waiver exist? When there is a knowing and intelligent relinquishment of a right, which is never presumed, and so I would just point out that I don't think Akamozo reversed any presumptions, but I think the test really does need to be whether the client had grounds to believe that the confidentiality would be maintained, and actually subjectively, reasonably believed that it would be maintained. On this record, I think we have those facts because of the letter. But I can well imagine that there would be cases where that would be more difficult to establish. But I think the combination of an objective reasonableness and a subjective belief is probably the most reasonable test that the court can adopt, because that at least provides guidance for trial courts.
Counsel, let me ask you a question then on that, the objective reasonableness, because I think that begs to build that out a bit. Because if I look at the current law of privilege and waiver, Akamozo aside, it would suggest that the presence of a third party then is going to result in a waiver of that privilege with very narrow exceptions. If we were to go with objectively reasonable, though, it seems to me then that it's the scenario of, well, then the exception becomes the rule, that a limited waiver, keeping in mind the nature of the attorney-client relationship, that you can avoid waiver anytime a client has an objectively reasonable, based upon their subjective belief, that they're going to be able to maintain the privilege. And as I say that out loud, I'm just as confused as I was when I started the question.
I think Justice Timmer gave us a pretty good hypothetical as to when it's not objectively reasonable. And that is, there are 10 people around on a speakerphone. The lawyer probably doesn't even know who the lawyer's talking to. At that point, the objective reasonableness melts away. But I would point out, Your Honor, that the Sucharu, and I hope I'm pronouncing that correctly, the Sucharu decision, which this court quoted in Clements only 5 years ago, contains that broad exception. The language the court quoted is, the court must ask whether the client reasonably understood the communication to be confidential. That was quoted by this court. It has been a long-standing rule under Sucharu, and I think that's the appropriate test.
So we don't look at, I'm sorry, I'm struggling with, how do we identify, though, whether or not the presence of that third party is objectively reasonable for what the client's belief is going to be? And the reason why I ask that is, I could easily see, someone saying, well, this is my longtime sorority sister. We talk about everything, and I want her here. And I say that because on the flip side of this, I'm also thinking about, well, what is the attorney's role? Isn't the attorney in the position supposedly to understand the client's concerns and do what they can to help them understand things? And if they need to put it down in writing and then the client wants to go back and share it with somebody and look it over, well, they could do that. But that would also come with the attorney then warning them that this is confidential. If you disclose this to others, it could be subject to discovery. So I guess I'm trying to think of the other side of the equation right now, too, and saying, are we in many ways now relieving the attorney of what their inherent responsibility is, which is to be able to communicate with their client?
Well, I don't think so. And I'm not suggesting that Akamozo answers that question, or if it does, that it answers it perfectly. What I'm suggesting is that it recognizes the attorney's role in informing the client of the risk taken when that third party is included in the communications. And notice I didn't use the word presence there, because the inclusion can sometimes involve serial communications. Sometimes the attorney may have concerns that even if there's no language barrier, even if there's no competency issue, attorneys often have concerns that the client isn't quite absorbing the advice. And I think the real test for these independent communications, Your Honor, should be whether the communications were designed to inform or secure information from the client. If the communications are so independent that the client is no longer receiving the advice, the client is no longer making the decisions, the client is no longer aware of the information that's being communicated, whether or not she understands it, I think at that point, you have a communication that has gone outside the scope not only of Akamozo, but of Sutchery.
So
And I hope that
how does
answers
the
your
court
question.
decide that? In-camera inspection of the communications, or how does that play out in the real world?
Well, I think there are going to be times when in-camera reviews are warranted, but always you need a predicate for that. You need some reason to believe that communications occurred that fell outside the, I'll call it Sutchery/Akamozo expectation that the client be involved in securing confidentiality.
But how would the person challenging privilege even be able to go down that road at all?
Well,
without
one way
knowing at all
in-
what the nature and extent of the communications were.
One way
I'm talking about communications between the lawyer and the third party in the absence of the client.
I may have trampled, Your Honor, but when I thought you were finished, and
Okay.
I think I missed part of that question.
Okay.
I'm sorry.
That's my question. How does the court determine, under your formulation, if the criteria that you've suggested are met? Is it your position that any communications that I guess we're calling independent communications between the lawyer and the third party in the absence of the client are still covered by the privilege? Is that your position?
My position is that physical presence is not required and contemporaneous communication is not required, but involvement is. And so if discovery evolves to show that there were communications with a third party that really didn't involve the client, then I think you have the predicate for an in-camera review. But here we don't have that, because here Ursula hasn't even been deposed yet. And I'm not suggesting that there won't be cases where that predicate would emerge, but in a family case like this, where we have a mother and daughter, I will acknowledge that that's a pretty hard predicate to establish, but not impossible. There may be facts where it becomes evident that the lawyer and the third party are essentially conducting the representation without the involvement of the client. And in that case, I don't think the privilege continues to exist. In other words, I think the privilege could be waived there, which is an important distinction that I think the concurrence in the Gelvin special action misses. It seems to conflate the existence and scope of the privilege with the existence of waiver. And most of our case law in this state on waiver involves situations where some position the client has taken in litigation places the advice at issue so that it's being used as a shield and a sword. This is not that. This is the much more mundane form of waiver where there's been disclosure to a third party. And I would just point out that this court has taken measures time and time again by rulemaking to prevent inadvertent waiver from happening that way. I would just point to Rule 26.1, ER 4.4. All of these are designed to make sure that there isn't an inadvertent waiver. I will agree that there are times when gamesmanship could be used to try and make everybody in the world subject to privilege, and obviously there are limits, but I think the combination of objective reasonableness and subjective belief coupled with an effort by the client to maintain that communication and advice from the lawyer of the risk of waiver should be enough to secure the privilege.
If the client is not present when the communication takes place between the lawyer and the third party, how can the client keep the communication confidential?
If the client is not present?
Correct.
Well, I mean, certainly the client's tools are limited in that sense, but one way is by choosing the right third party. And I would suggest that it's often going to be the case that your mother is the appropriate third party who you can trust to keep it confidential.
Well, does that mean that you're going to have, then if the mother talks to the daughter about what was discussed with the lawyer, is that now also subject to the privilege?
If the mother and the daughter are discussing the legal advice, I think it would have to be, because they might, if we imagine the situation in Akamozo where there's physical presence, there's a three-way conveation happening.
Yeah,
And the mother and daughter might exchange views about the advice. That wouldn't waive the privilege. I
Just
don't
one
think.
on the, before your time runs out, on the issue of retroactivity and prospective application, As you know, in civil cases, our opinions typically apply retroactively as well as prospectively, but we have a three-part test that we laid out in the Cundiff case. I'm struggling a bit with that. Take me down through those factors and let me know your position on why this shouldn't be applied retroactively, whatever we decide.
I'm glad you brought that up, Your Honor. That was the first point I wanted to address because obviously it's the most important point to my client. I'll take you through the three-part test, but I would submit, Your Honor, that if this rule or any rule established clearly by case law can be simply changed retroactively so that the public's reasonable expectation of the law is no longer firm, the victim is not only the client, is not only the lawyer, or the thousands of lawyers and clients who have Akamozo-type arrangements who might then find themselves in, either releasing privileged information, victimizing the client, or a malpractice action against the lawyer. The real victim is the common law itself. Because if the message to the public is that you cannot rely on a published decision of an appellate court of this state because we might change it down the road and your rights will be erased, that's chaos. And I would urge the court not to go down that road. Now, on the three-part test, Akamozo has been...
Rather than doing the three-part test, and I realize your time is almost up, I think that your opposing counsel concedes the prospective point, but believes that the trial court got it right, and that's partially prospective, but that Akamozo did not encompass everything that the Court of Appeals concluded that it did.
Well, Your Honor, I did hear that. May I continue? My time has expired.
Well,
You may.
it's her call.
My call.
Your Honor, I did hear that, and I don't think the trial court had the predicate, getting back to some of my early answers, had the predicate to say what these communications were, to say that they were independent. There would have to be some showing. Now, Tina has been deposed. Ursula has not in this case. There would have to be some showing, again, that the communications exceeded the scope of the representation of Tina and that they went to some other matter, I think, before that category can legitimately be swept in. What I heard my colleagues say was that these independent communications were just about strategy. Well, that's mere speculation. Nobody knows that. I don't even know that. So you would need a predicate, I think, to say that we've exceeded the scope of proper communications about the case as it relates to the client, her decision-making, her being informed of the advice, etc., before you can simply draw that line. Akamozo didn't do it. Akamozo didn't have those facts before it.
I think you're at the end of your...
I'm
I
sorry?
think you've answered his question.
All right,
You're
fair
well
enough.
over your time.
Can I
I
ask
appreciate
one
the
more quick
extension.
question?
Thank you,
You
Your
may.
Honor.
Go
All
ahead.
right, with respect to that, does the other side have to make a showing before we get to an in-camera review to figure out what those communications were about?
The brief answer is yes, and I would suggest to Your Honor that that is true of every in-camera review situation I can think of, and if the answer is no, that would mean that in every case, everybody would just ask for an in-camera review, and I think that's a slippery slope.
Let me have a question. So wouldn't the predicate to that, though, shouldn't we require the person asserting the privilege to make the showing? Akamozo seemed to suggest that there's a presumption. If the wife here is asserting that these communications are privileged, isn't it up to her to establish that the privilege would cover those? I know you said this is about waiver, but it would seem that the other side of that coin is asserting that, well, the privilege does apply to these particular communications involving the mother. Isn't that the wife's burden to establish?
It is clearly the wife's burden to establish that the privilege applies. In this case, there's been no suggestion that the privilege doesn't apply generally. So the only question, I think, as my colleague has narrowed the issue today, The only question is whether there's been a waiver because some of these communications were quote-unquote independent. And that showing, I think, is insufficient. I suppose the court could adopt a burden-shifting approach that requires the client to say, all of these communications concern me and address the facts that gave rise to the initial predicate. But I hope that answers your question. Thank you.
Thank you.
All right, thank you.
Okay. Mr. Reisinger, you have 52 seconds, but I'll give you, can you add a couple more minutes for him, because in fairness, Mr. Swan went over as well, so. Not that it's your fault, we asked a lot of questions.
I can only speak for myself, but I think we both appreciate the court's questions because this is an interesting and difficult issue. There's a case in New York called Molnar versus Molnar with very similar facts to this scenario. I believe it was cited in the concurring opinion below. In that case, the court rejected the wife's claim that involving her parents did not vitiate the privilege because she did not produce evidence to show that they were necessary to those attorney-client conferences. And that is the appropriate burden when this privilege is asserted in order to prevent discovery of information. The Accomazzo case reverses that presumption. It presumes that the parent's involvement is privileged, and therefore the opposing party must somehow make a showing that the privilege was waived. And I would posit to the court that that's impossible for a few reasons. One, what evidence could possibly do that? And two, when seeking discovery, the party doesn't know that this Accomazzo agreement exists. They're asking for communications with a witness, and then the privilege is asserted, and then the Accomazzo agreement, if there's one in writing, is disclosed.
I rather wonder, I mean, practically speaking, if you asked for communications between the lawyer and the third party, and the objection then is simply, oh, that's privileged, wouldn't it be just as simple to say that, well, if there was a privilege, it's waived or it's non-existent because it doesn't involve the client? Doesn't that just automatically put the burden on them anyway, whether you are tasked with being the one to point that out, that there's no relationship with a third party?
I believe it does. And I think the Accomazzo case is perhaps an example of bad facts and a bad trial court ruling creating some counterintuitive law. Because in the Accomazzo case, the trial court treated the presence of the parents in the attorney-client conferences as a complete waiver and ordered the attorney in that case to be deposed and to disclose all communications about the premarital agreement. That's much different than what the trial court did in this case. Because the trial court in this case has done everything it could to preserve the attorney-client privilege within the confines of that relationship, but still allow Mr. Gelvin to seek discovery from that third-party witness who's alleging that she's part of this privileged relationship. And just to clarify the record below, there is currently a deposition pending and a motion to quash pending that the trial court stayed in advance of this hearing when the court granted review. So the issue of whether Mr. Gelvin can simply depose Mrs. Giebert and get the information independently of whatever communications she had with her daughter or her daughter's lawyer remains pending, but objections, of course, have been filed, and we expect to have this entire discussion at the trial court level. Thank you.
Thank you. Thank all counsel for their briefing and the argument today. Very well done, and give us a lot to think about. We will take the matter under advisement and issue an opinion in due course. We stand adjourned for the day.